Hello and welcome to this Russell-Cooke webinar. I'm Carla Whalen, I'm one of the senior associates in the charity team. Originally this webinar, or the slides that we're going to look at today, would form part of the evening seminar that we were planning on data sharing. As many of you might know, we run these free seminars for charities and not-for-profits regularly throughout the year, and you know it's really great opportunity to have a conversation with all of you about your experiences and to share our thoughts. Unfortunately, in the current situation, that's not quite so easy to achieve. So today I'm just going to be recording around about 10 minutes of a proportion of what we were going to do at the seminar. And at the end, you'll see my contact details, and it'd be really great if anyone wants to get in touch and let me have any feedback or questions, thoughts, sharing your own experiences, or even suggestions for future webinars like this. So as I say, around about 10 minutes today, focusing on the topic of subject access requests and taking as a starting point a hypothetical scenario. So let's imagine that your charity, and for reasons we'll get into in a moment, let's say your finance director, so someone who's not a data protection specialist, someone who's not your data protection officer, your finance manager gets a phone call really out of the blue from an ex-employee who's recently left. Let's call her Ali. And she says, I know people are talking about me and I want to see everything, every email, every WhatsApp, so I can see what they're saying. She then says that she wants a response by the end of this week because she's going to see her lawyer on Friday. So I'm sure many of you are thinking, oh, nightmare scenario. So we're going to pick this apart and just really look at how you might manage this basically from start to finish in 10 minutes. So first question, is this a valid subject access request? So focusing on two things. Firstly, the fact that this is just a phone call and, you know, Ali hasn't put this in writing and it's just been made to your finance director. Does that affect the validity? Well, in a nutshell, no. The GDPR, the Data Protection Act, none of the legislation says that requests have to be made in writing or that they have to be made in a particular format. So the ICO's guidance, that's the Information Commissioner's Office, the ICO's guidance on subject access requests is really clear that you should be prepared to get a subject access request in any format, so social media, in person, face-to-face, over the phone, all kinds of media and ways of communicating are valid. Now, that doesn't mean that you can't ask people to use a particular form or at least to put the request in writing, and it can be really helpful for kind of consistency and being clear about what's being asked and what you're being asked to produce, to have a written form and to ask people to put something in writing. But you need to be aware that if they refuse, the request is still valid and you still need to do your best to comply. Secondly, she just says, I want to see everything. Is that a subject access request? Again, the short answer is yes. Don't have to use a particular form of words. You don't have to refer to the GDPR. You don't have to say subject access or anything like that. So that poses a bit of a challenge really for your staff who are working, you know, on the front lines really, because anybody could be asked to produce information to, you know, action what is essentially a request to exercise an individual right under the data protection legislation. And you really need to train your staff to be able to recognise those requests or recognise when someone might be trying to make those requests. Now, that doesn't mean you need to train every member of staff to actually be able to then follow through with all of the other actions we're going to talk about today in order to respond to the subject access request. It just means that staff need to be alert to thinking, I think this might be a subject access request, and then know who to go to report that a subject access request has been made so that it can be actioned and taken forwards. And that needs to be really drilled into people, that it needs to be done without delay and they shouldn't sit on it. We'll come to look at timescales for responding shortly. Before that though, the second sort of point about whether this is a valid subject access request is that Ali has told your finance director basically that she intends to go and take legal advice, and we know that she's an ex-employee and she's recently left the organisation. So I mean, that probably tells us that she may well be looking for information to share with her lawyer. This could essentially be a bit of a fishing exercise. Does that affect the validity? Well, again, really no is the sort of short answer. There was a case a few years ago involving a law firm, Taylor Wessing, which made really clear that subject access requests are purpose blind, is what the court said. So it doesn't matter why you're looking for the information, even if it is to support a legal claim that you're going to bring against the organisation. The point is, you've got the right under the data protection legislation to see what people are processing, what data people have about you, and then you can do whatever you like with it. There is a slight sort of caveat to that, I suppose, which is that the data protection legislation does allow you to refuse to comply with a subject access request if it's malicious in intent, or is kind of being used to harass somebody. This would fall under the sort of manifestly unfounded, is the wording used in the legislation, the manifestly unfounded exception. Now, the legislation doesn't say what exactly counts as manifestly unfounded, but the ICO's guidance says, it could include, for instance, a request made by someone that involves unsubstantiated allegations or accusations against particular employees, or someone is sort of really targeting a particular member of staff against whom they have a personal grudge. Now, I think you have to be quite cautious about refusing a subject access request on this basis, and you would have to have, I think, quite a high bar to get over, quite a lot of evidence to suggest this is a malicious request. Because, as I said, the case law is quite clear that simply the fact that this is a request in the context of someone thinking about bringing a claim isn't enough to make it invalid. So, do you need to ask for ID? Now, back in the old days, under the old legislation, the Data Protection Act 1998, people regularly asked for ID and asked for a fee of £10 as standard, which is, again, no longer a standard part of the procedure, in order to basically delay the timescale for responding. So it's still the same situation with the GDPR, that the timescale for getting back to someone with the subject access request doesn't actually start until ID is provided. But it doesn't mean you can use that as a way to buy some more time. You really shouldn't ask for ID as a matter of course. You need to ask yourself, is this required? Now, there's total right and provisions under the GDPR for you to go and ask for ID, but only if it's required. So here we've got someone who was a long-serving employee who left not that long ago. It depends on the size and the nature of your charity, but there's a good chance, I think, that your finance manager might actually be able to recognize that person's voice over the phone, and that would be enough to identify the requester. Even if they couldn't just be confident that they can identify by voice, it really shouldn't be necessary to request that person's birth certificate or passport or something like that, utility bills. If it's an ex-employee, you should have all kinds of bits of data that you can use to confirm that they are who they say they are. So you'll probably have their date of birth, their postcode. You might have, an employee ID number that was unique to them, something that you've already got that data and you can use it to identify them. So proportionality really is key. And, the ICO does get complaints from individuals saying that organisations are being unduly sort of formal in asking for information in order to carry out ID checks that frankly they're not entitled to see. So do be careful about that. So moving on, assuming that we accept that Ali is in theory able to make this request and that it's a subject access request under the GDPR, and that secondly we know that it is her asking for the information, we then come on to, well, what's she asking for? And you remember she just said, I want to see everything, every email, every WhatsApp, every message. That's a lot, and particularly if she's a long-serving employee, you could be talking about tens or even hundreds of thousands of files. if you think about, you know, every email and every document that might mention her. You can ask for clarification. The GDPR completely allows, I think it's recital 63 of the GDPR, permits controllers, data controllers, to ask people making subject access requests to clarify what exactly they're looking for. Now, again, proportionality is key. You can't use that as a way of kind of delaying or making life difficult for the requester. If all that you've got about them is the fact that they're on your mailing list, then clearly you don't need to ask for any further information. You just give them everything you've got. But where it's something like this, where someone's been a member of staff for a long time, for instance, has a long relationship with your organisation, ask for clarification. Key though, this does not affect the timescale for you to respond. So if you ask for clarification and the person doesn't provide it or doesn't provide it in good time, the clock is still ticking. So you are advised to ask. It's a good idea to ask, and it can really help you to focus. But if the requester says, no, I'm not going to tell you, then you've still got to comply. Again, subject to that exemption I mentioned about the request being manifestly unfounded, or another exemption is excessive. So manifestly unfounded or excessive. So obviously the more information you have and the wider the request, the more likely you are to be justified in saying we're not going to comply because this is manifestly unfounded. Sorry, this is excessive. Or that it will give you the right to charge a fee. Now, I mentioned that the £10 fee under the old legislation that was sort of automatic is no longer in force, but there is a provision that says in the new legislation, in the GDPR, that you can charge a fee if there's an excessive or manifestly unfounded request. So if someone asks for 10 copies of everything, for instance, you can charge them a fee for that. There's no set fee. You've got to work out what's reasonable. And I think, you know, the ICO's guidance suggests, and I think it's right, that you should do that in accordance with working out how long it's going to take you to comply, and then assigning a figure based on that amount of time. And obviously that can be a good way of almost sort of forcing the individual to clarify their request, because if you say, okay, well, you're not going to clarify, but we've got 20,000 documents and it's going to take us 4 days to go through these, so we're going to charge you £200, that person might then say, oh, okay, I'll clarify it, this is what I'm looking for, and then you can get back to them. So I've mentioned a few times already the timescale for responding, and the short legal answer is that you've got 1 month from the date of receipt of the subject access request, or I mentioned receipt of the ID if you need to request it and that comes in later. So 1 month. That can be extended by a further 2 months if the request is complicated, or if you receive several requests. And you'll see on the slide here, I've called this the legal answer because that's the position under the legislation. I think it's helpful though to think about what we might call, I've called here a pragmatic approach, or a kind of practical approach. Thinking about the way in which this employee made the request, how she sounded on the phone. I know that you just had me doing a quite rubbish impression, but you know, she's obviously angry. She doesn't seem happy. She seems to really think that everyone's out to get her, and she seems to be ready to bring a legal claim against the charity. So if you respond very legalistically to her and say, you know, I know you're going to see your lawyer on Friday, but you've got no right to get these documents until, you know, we've got a month to do this, and we're going to take our time, she's just going to feel, you know, dig her heels in even more, feel more entrenched. A pragmatic approach might be to say to her, there's loads and loads of documents that we've got. We're going to have to go through them carefully. We've got up to a month under the legislation. But if there are specific documents that you're looking for that you want to take to your meeting on Friday, let us know and we'll do our best to look at those first and to get what we can to you. You can see that by sort of taking that more understanding approach, it's much more likely that you can kind of take the heat out of it, and she might then cooperate with you further in kind of limiting what she wants in her request and being reasonable about, you know, what she actually wants you to do, rather than just using this as essentially a form of punishment to make you suffer. So as I say, there's the kind of legal answer, which you're completely entitled to rely on, but there might be cases where taking a kind of compromise, pragmatic approach might be quite helpful, and doing it in tranches can often be a good way of making everyone happy. So searching and collating the information. I'm sorry, the heading on this slide says ID check, but it actually should have been the responding to the subject access request. So this is the final stage. You have clarified, or not, as the case may be, what you're looking for. You now need to go and get it. So obviously you're going to search all of your systems, electronic and filing systems organized according to the employee's name or other details that you can search through. So say, a unique employee ID number or something, or a job title that you'd be able to search for paper files relating to that particular person. A couple of key points, and we could do a whole webinar on how to actually sift through information, and that's not for today. But as I say, a couple of key points when you're searching and collating. Firstly, always remember that Ali is only entitled to her own personal data, so documents that relate to her. Now that might mean that there are whole swathes of documents that she'd like to get her hands on, which she's not entitled to under the subject access regime. So that could be, say for example, she's been made redundant, and it was part of a bigger redundancy exercise involving lots of employees. She wouldn't be entitled to see management documents that don't refer to her specifically, just refer to staff in general and the rationale for making for reorganization and for making redundancies. If it doesn't relate to her specifically, she doesn't get that. Equally, she can't ask to see documents relating to other employees, for example, who were scored as part of a redundancy exercise and came out higher than her. She couldn't see their information. Now, it can get a little bit complicated if there's a kind of document that is a mixture of two things. There's a little bit about Ali and there's a lot about other people. And in that case, probably what you would do is redact, so remove all the information about other people and just give her the information that relates to her. And then the second point being that only the charities filing systems come within the scope of the subject access request. Now, if you cast your mind back right to the start when I gave you the scenario here, she mentions WhatsApp messages. And that's a classic sort of question about whether those WhatsApp messages actually form part of the charities filing systems or not. In most cases, WhatsApp isn't sanctioned as a work mode of communication, and actually it's more likely that staff have just set up a WhatsApp group between them for their own personal use, and that's not part of the charity's filing systems. If, though, the charity did decide it was going to use WhatsApp for a particular service, and therefore, accepting that it's part of their own systems, then those messages would fall within the scope of the subject access request. This usually gets a bit tricky if people, particularly trustees in charities, get to use their personal email addresses or personal devices, because they sometimes lose sight of what's official charity business and what is their own personal communications, and they often really don't want to give up certain emails as part of a subject access request, when actually, because they are using their personal email address for charity business, it's all disclosable. So best practice is to just make sure that even trustees have charity email addresses, so the delineation between work or official business and personal communications is really clear. And then finally, once you've got what might be a very large pile of documents, you need to go through them and review them carefully. And this is extremely time consuming in a lot of cases, but there's no easy way around it. There are a number of exemptions that can apply that mean that you don't have to disclose whole documents, or maybe don't have to disclose sections of documents. So that could be that there's information that's legally privileged if you've got legal advice about Ali's case at some point. It could be that there's personal data relating to a third party that she really shouldn't see, and it wouldn't be fair to disclose that to her. It might be that there's business sensitive information. For instance, I mentioned perhaps there'd been a redundancy situation, if there were documents that talked about Ali, but also talked about the fact that there would be a second tranche of redundancies which haven't yet been announced, then that would be the kind of information that really shouldn't be disclosed to her because it's business sensitive management information. And then finally, when you go back to her, the GDPR requires you to provide some additional information. That's things like how long do you keep the data, why have you got it, what do you use it for? A lot of those things that will probably already be in your privacy notice, your privacy statement or data protection policy, whatever you call it, the information that you provide to people. So you could just link to that or provide a copy of that, but you do need to make sure that you cover off all those things when you respond. So that's the end of this short webinar. There's my contact details on the screen. So please do, as I say, give me some feedback. Let me know what you think. If you've got any questions about any of that. Hopefully it's been quite a helpful way of thinking about responding to subject access requests in a kind of proportionate but also compliant way. Hope to see you again soon.